Hey guys, so welcome to another video of Silent No More. I know I haven't posted one in a little bit. I've been insanely busy with different things going on in my own personal life with my ex-husband and different court hearings and motions and things that we were going through that unfortunately I had to focus on finding attorneys, filling out paperwork, helping my children. Anyway, basically, back in October, my OFP extension that I had previously filed 2 years ago was going to expire, so I needed to file for a new extension. I ended up filling out all the paperwork for that. Wrote my own statement, submitted therapist letters, a guardian ad litem's recommendation from Wisconsin stating that she recommended no contact and that she finds that there is evidence that my ex-husband abused our children. I also cited in there our recent Wisconsin court case that he was denied parenting time there and that he, of course, is dragging this out through his judicial rights process. Due process, whatever you want to call it, and forcing us to go through with this evidentiary hearing in February, despite the fact that he's has no reasonable expectation that he is going to get a different answer, because the judge in Wisconsin has restricted his access to what he is allowed to know. All he's allowed to know is a summary of like my children's diagnosis and like the blanket of what he's been accused of, which he actually already knows. He's just trying to be difficult about it. So they demanded this evidentiary hearing so that basically they can get more information. Confrontation costs money, drag me to court, put me in a position where he knows I'm going to be and basically stalking me and harassing me and financially abusing me with the permission of the court who indulges him. So anyway, all of that was included in my statement. My oldest son, who is 10, decided he needed to write a letter to the judge. He wanted his voice heard on this order for protection. And we deemed in therapy that we thought that this was fine and appropriate because he kept saying he wanted to testify and talk to these judges. And we said we didn't know if that was needed or necessary or if it was going to happen. And also that in the past, when I had filed for order for protection extensions, my ex-husband never contested them. There was no need for a hearing. Therefore, if that was the case this time, there might not be a need or a chance to talk to a judge. So we agreed that he could write a letter saying whatever he wanted to say, what he felt like he needed to tell this judge. In that letter, my son disclosed abuse that we did not know about. We, obviously over the last couple of years, have discovered, the kids have come forward in therapy with different allegations, that their father had not only physically abused them, mentally abused them, threatened them, the domestic violence that was obviously apparent and why we left and everything, but had also been sexually abusing 3 of the 4 of them. Now, while some disclosures were made and reported and all of that, obviously, if you listen to or watch my previous videos, you know that CPS New Ulm, Minnesota completely dropped the ball and didn't give a crap. We were old news. They didn't want to waste their time and resources. I had an OFP. I should just be happy with that because I have this piece of paper. My kids aren't in imminent danger of him. Therefore, nobody feels the need to step in. That kind of bogus bullshit, which I'm telling you after talking to attorneys should not, right, that is not how the system should work. Even with an OFP, your children still are in imminent danger. CPS should still be opening up cases against the abuser to protect the children. That is a serious contention and loophole and problem in the system. All of that aside, my son, the very first thing he wrote to this judge was about his father raping him. Had no idea. Nobody knew. He told me that the reason why he never told anybody was because his father had told him that if he said anything, he would kill him and make it look like an accident. He had also apparently threatened my life. And so my son said that it was okay that I didn't know and that I didn't protect him because if I did that, then I would be dead or he would be dead, and he felt responsible for that. No monster should ever get away with doing that to a child, to saying that to a child, to threatening that to a child. We are still waiting to hear if they are going to pursue charges or not on this, because my son went and did a police interview the day we turned in our OFP paperwork. He talked to an officer. He gave an interview, not only about that, but about the domestic violence, about what he witnessed his sisters go through, about witnessing another woman being raped in our home by my ex-husband. Just horrific and disgusting things, deplorable. No child should ever experience that, let alone a young child. And my son wanted to be heard. So they contacted my ex, of course, to let him know about these allegations, to give him the opportunity to respond. He, of course, again, is refusing to be interviewed, just like he was last time, except this time he's claiming he wants his lawyer and everything to go through his lawyer. Now, he's had the same attorney through everything. I actually, like I've mentioned him before. It's Andrew Loffers with Cordell and Cordell. Their website purports them to be father's rights movement attorneys and all that jazz. If you actually do the research on their website, the things that they write for advice to men going through a divorce, like the top 10 mistakes, I think it is about child custody, is all very anti-mother, anti-woman, assume you're being recorded, planting the seed of paranoia. And, if you have an anger problem, don't hit your wife. Don't hit your children. That's not going to look good for you. Not that it's wrong. Not that this makes for any other big serious concerns, but this is just a bad idea. The stuff that's written on there is absolutely horrible after doing a bunch of research and digging. I then went on to do research on this person, multiple resources, including Better Business Bureau, Yelp, Avo, starlawyers.com, all of that stuff. And while on their website, they purport to be amazing, 5-star rated, glowing reviews, every other website, including the Better Business Bureau, has a 1-star rating, talks about them being absolutely money hungry and that they don't give a crap about their cases, about their clients, because they are just in it to milk the money, which, helps explain, I guess, why somebody would represent somebody who has done such horrible things to their children and then is trying to claim it's their constitutional right to have access to their victims. It's not because it's what they probably truly believes. It's because he wants to line his pocketbooks. So, there was actually even a review written on there by a man who had gone in to actually he had a 50-50 custody arrangement and was trying to make things more equitable because things weren't written clearly black and white. They were very vague. And I don't know this man's story. I don't know what the situation was with the divorce and whatnot. But the review said that his attorney, through Cordell and Cordell, made things worse for him. Not only did the situation that he come to not resolve, but he actually left with less time with his child, less custody, and 25 contempt charges, jail time, and thousands of dollars in fees on top of thousands of dollars in lawyer fees. Just to give you an idea of the kind of people that claim their father's rights but decide to represent abusers, pedophiles, and maybe possibly throw in some real dads into the mix. So anyway, that's my spiel on that. So I turned in all of this stuff for this, order for protection extension. And basically what happens after that point is a judge can grant it, pick a time frame. A judge can say, I want a hearing on this matter. A judge can deny it. All of those things. I had requested in my statement that because this was my third order for protection, because there were 2 violations, because of the abuse my children had endured, and because of him constantly taking me to court every 6 months in Minnesota and Wisconsin and draining me dry and using the system to abuse me, that I wanted the maximum amount possible, which was 50 years. These kind of orders for protections are unheard of. They just don't, not only do they not hand them out, they rarely ever happen. My domestic violence advocate has only ever heard of one other 50-year order for protection, and it was well before her time. So these are not given with a grain of salt. I then get a call a couple days later saying that the judge granted my order for protection and he granted it for 50 years. Amazing, right? Well, part of the process and the statutes and the rules are that after my ex-husband is then served with this, he has 5 days to respond, saying whether he wants to contest this or not. If he does not respond in those 5 days, the order just stands. On day number 4, he decided to contest it, which then brought about me scrambling to find a Minnesota attorney, trying to figure out how in the heck I was going to pay for it. Because I don't qualify for legal aid over there. I don't have money laying around. I still have a Wisconsin court case going on. I'm still raising 4 children. And I can't afford to keep doing this because cases like this, run you the gamut of, $800 to thousands of dollars, depending on what kind of trial and time you're looking at. Found an attorney. I used actually the same attorney I had used before. He had actually also prosecuted my ex-husband twice. So worked out a deal with him, and basically we had picked one date, was all set to go for that. Last minute, I find out it's changed because it was not convenient on the other end. So I then had to rearrange my whole life again and get another date, which I had specialist appointments for my children scheduled for that they had been waiting months to go to. Had to cancel them, had to reschedule them, which was not easy or feasible, and now I have a child waiting longer to see a specialist that they were supposed to be seeing like right now because she has a time frame on when she's supposed to have follow-ups. So that was annoying in and of itself. Then I'm told we have to prepare for a trial. Like, this is a full contested OFP hearing, not, we're nitpicking some things. Like, this is a full contest. Like, this is a trial. You're going to testify. He's going to testify. We need witnesses brought in here. We need evidence, like the whole kit and caboodle. So I then spend days writing a 45-page statement about how and when my children disclosed each and every incident of abuse, their fears, their triggers, how terrified they are of this man, that they can't even handle the word dad. They won't even say his name. They spell it out or they call him something else completely altogether. And, the different horrific things that he's done. I had to include my own experiences of domestic violence. I also included in there the fact that when we were trying to get divorced and he was stalling the process, we were actually scheduled for like a jury trial for our divorce because he wasn't responding to anything. Then right before, like a week before we were scheduled to go to court, we get an email from his attorney stating that he is willing to sign the MSA as long as I drop my order for protection and I drop any and all criminal investigations against him. What freaking attorney, seriously thinks that's an okay MSA proposal? Obviously, I said no. I'm entitled to an OFE, not dropping it. Certainly not dropping a criminal investigation against you. And even if I wanted to, I couldn't because that's out of my hands. So we ended up going to this trial date for our divorce. And his attorney at that point was actually kind of fed up with me, owed him money, got him to sign the papers that day. So included that in there, because obviously, if you're an innocent person, if this is not something that's a concern, why would you put that in a marriage settlement agreement? And whatnot. So, and then I had to get my kids ready, because now, my son, who was wanting to testify, was going to be testifying. I was then asked if my oldest daughter would testify. And initially, I had said no right off the bat. I didn't think she was ready. I didn't think she could handle it. I didn't want to put that on her. But then she actually said she wanted to. Her only concern with testifying was that she thought that as soon as she started talking, that her biological father would jump across the table and harm her in the courtroom. She was also concerned that when we went into the courthouse, that as soon as he saw her, he would touch her, harm her, do things to her. So we made it clear that she would be safe. You know, we had BACA on board. We ended up actually having like 8 bikers, I think, show up yesterday for this, and whatnot. So, you know, therapy sessions. So we went through a lot of hell, a lot of emotional turmoil, waiting and preparing for yesterday's trial for this order for protection. We get there, before he does, you know, me, my kids, you know, my friend, like these 8 bikers, we all go into this conference room. We're sitting, waiting. My attorney finally shows up. You know, I have 2 domestic violence advocates there. We're discussing what the possible rundown of like how like events like are going to take place, like kids testifying in chambers. Here are the questions I'm probably going to have to answer. You know, when his lawyer asks me a question, don't answer right away, pause and wait so that my attorney has time to object if he needs to. You know, that my ex is going to testify. He didn't bring any witnesses. From what he could tell, he didn't submit anything. So we didn't know what his game plan was other than to sit there and call us liars. So we said, okay, fine, you know, whatever. It was getting to be past the point where our trial was supposed to start. And then my attorney was brought into the judge's chambers. Initially, the conversation for that was basically just talking about the kids testifying in chambers and how that would work. Because if they go into chambers, then the court reporter would have to go in there, my attorney and his attorney. There would not be video streaming. So my ex-husband would not be viewing their testimony whatsoever. BACA would be there, you know, outside the room, inside the room, whatever, so that the kids felt empowered and safe and whatnot. My ex completely was caught off guard. He did not anticipate me not showing up alone. He didn't anticipate me having, you know, friends there. I'm sure he probably expected, you know, obviously the lawyer and an advocate, not 2, but not, you know, a friend, 2 advocates. My children who were sitting in a room going, let me talk to that judge. I want to talk to him right now. And 8 bikers. So we saw his demeanor start to change quite a bit. Like, he was already agitated and angry when he got there, like he always is. But his face went from like white to like beet red, as red as my jacket. Very tense body, you know, shifting. You could tell that as things were being discussed in the hallway that he could overhear on our end, he was getting more and more agitated. Then both attorneys were called into chambers again to talk to the judge. And then my attorney comes out after a while and says, so there's some shenanigans going on. I said, what else is new? There's always shenanigans when it comes to him. What's going on this time? And he said, well, now he's willing to agree to this 50-year order for protection, but he wants to do it without findings of domestic violence, which means you're not testifying, your kids are not testifying. He's just going to acquiesce to this 50-year OFP, and then he wants the addendum on there from our modification a year ago to be re-put in there that says that Wisconsin, you know, Pierce County Court would be the ones to determine any stipulations for contact with the children, even though they've already said no, and that's the other whole ball and wax. And I said, well, isn't that kind of like what we're originally, like, why did you bring me here for this? Isn't that basically what it says? And my lawyer said, well, no, your current, the OFP that was just signed is just like your original order for protection. It actually bans him from pursuing anything with you in Wisconsin. If the order stands the way it is now, he cannot take you to court in Wisconsin for 50 years. And I said, well, what the heck are you talking about? I said, because before this was modified a year ago, we were in court. He was trying to get custody of these kids. He was trying to get visitation with these kids. And that's when he told me that that was a direct and blatant violation of my order for protection. And not only should the Wisconsin judge have not entertained it, he should have been arrested. I didn't know that. I don't know if the judges over here didn't know that, or if they just looked the other way, or if they thought it was okay because it was wrapped around this divorce sandwich, or what. So again, he blatantly violated the order for protection and got away with it. But it was now brought to his attorney's attention that if the order stood the way it was and he proceeded with taking me to court in Wisconsin, he would be arrested because he would be violating this order for protection. So there is one of the loopholes we have been looking for when I've been talking to senators and people and trying to figure out how in the hell he keeps being allowed to drag me to court. This little addendum he wanted added, this simple sentence that says, that our, family court custody stuff is to be determined in Wisconsin per our marriage settlement agreement. Sounds innocent enough, sounds simple enough, but it's too vague and it's too broad, and that is what allows him to continue to take me to court in Wisconsin whenever the hell he feels like it, until we get a Wisconsin judge to tell him to knock it the hell off. So I immediately was like, no, I don't agree to this. I don't want this. My attorney was asking me to think about it because, if we did a trial, we would kind of be gambling, about how things would get written, how that things would get granted, and all of that. And I said, well, why does it matter? I should be allowed to have this voice. I had a meeting with my friend, with my advocates, with the BACA liaison, asking what they thought I should do, what, if I should try go in there and testify, have these kids testify. That was when she told me that my daughter's demeanor had changed. She went from being scared and apprehensive to ready to get in there. She wanted to go in there and talk to this judge. She was ready to stand up. My son was in there yelling, let me talk to this judge. I want to talk to him. I need to talk to him. So I said, that's it. Done deal. I'm not agreeing to this. I want a trial. I want to go in there and I want to have testimony. I want to submit evidence. I want the judge to review it all. My attorney goes back. He says all this. Then comes back and tells me, apparently there is this stupid statute in Wisconsin, or not in Wisconsin, in Minnesota, that says if a person who has contested an order for protection is now willing to acquiesce and, in essence, plead no contest, and allow you to have this order for protection against them, you cannot testify. You cannot have a trial. You cannot speak. Your witnesses cannot speak. They are allowed to silence you. So we then had realized, okay, now we could go into this hearing. It's no longer a trial. And basically the only thing we were supposed to be debating was the stipulations of this order for protection, mainly this addendum that they wanted added. I told them, I said, this is complete bullshit. You're giving him all of the rights. Everybody is concerned about his rights. Everything is about him. What about my rights? What about my children's rights? Why don't we have the right to be heard? Why don't we have the right to speak up in a courtroom? If he has the right to drag me for a trial, why can't I then say, you know what, the trial continues, whether he changes his mind or not? Why can't I request a trial? Why am I denied this? Why are my children denied this? No answer. No answer whatsoever on this other than, I'm sorry, this is a shitty situation and it is what it is. I told my attorney I wanted him to make it clear to this judge that I was not in agreement with this. I wasn't okay with this. I wanted it on the record. I wanted a domestic violence. I wanted an OFP with findings of abuse. Because with that, not only is it on the record, but it gives me more protection. It gives my children more protection. And he can't keep pulling this crap in Wisconsin. Wasn't going to happen. So we go in, we sit, do the whole, rise for the judge, sit down, a judge acknowledges who's all here. He asks my ex, okay, so you're saying you're agreeing to this, order for protection. Yes, I am. Okay, well, do you feel like you've had enough time to talk to your attorney, to think about this, review it, talk to anybody you might need to talk to? And he said yes. My attorney then says, you know what, it needs to, like, I know I've talked to you in chambers. I know what your ruling is. I know what your decision is. But I would like it to be known that my client disagrees with this. She wants a trial. She wants to testify. She has 2 children out there who really want to talk to you. They want their voices heard. There is domestic violence here. There is horrific child abuse here. We're talking about, he hasn't seen these children since 2015. This abuse occurred when they lived with him, which means they were very young children. And he's like, we're talking about horrific child abuse, physical abuse, sexual abuse, rape, witnessing domestic violence, witnessing sexual acts, witnessing sexual assaults. We want you to know that. We want you to know that we want that on the record. Judge, sits there, thinks about it, and says, well, we're not going to have, the trial. We're not going to have this testimony. I understand that these children want to speak to me. I understand that they want to be heard, that they want their voices heard on this matter, that this is important to them. But he was not going to do it. And the other part of that, which we found out prior to going in, was I asked if my children could talk to the judge off the record. Just let them go in there and talk. As part of closure, as part of healing. Just let them talk to this man off the record. You don't have to record anything. It doesn't have to go on the court file, nothing. The only way for that to happen would be for both of our attorneys to agree to it. My attorney agreed. His attorney refused. He said he would not go in there and be a part of that. He would not hear my children. It doesn't look good. If you're a father's rights attorney, yeah, I get that you're for the father, but you're supposed to be like advocating for children too, and you're claiming that their father is the best thing for them. Freaking hear them out. Let them talk. But no, so we were not allowed to do that either. The judge also then said, because he was aware of the Wisconsin order that severely limits the amount of information my ex-husband is allowed to have about these kids, and anything that they're going through, and what they're doing. He was worried, I guess, that if these children came in and testified, even though they weren't testifying in front of my ex-husband, that his lawyer would be getting information that my ex-husband is restricted to, and that the attorney would then turn around and tell my ex-husband these things. So it was kind of done also to protect my kids and to make sure that Minnesota was not violating the Wisconsin order. Then we're talking about the length of this order for protection. Now, remember, my ex-husband said that he would agree to a 50-year order for protection, as long as there were no findings of abuse on the record. Well, him and his slimy attorney decided to change their minds on that. We're standing in the courtroom, and instead of being like, yep, 50 years, his attorney then goes, well, the language is permissive for up to 50 years. You don't have to do this for 50 years. You can pick any time length you want. We would like you to make it shorter than 50 years, because that is a terrible length of time. That's a really long time. And it was like, are you kidding me? Like, for once, could you maybe just stick by your words in some form or fashion? Just a little bit. Didn't matter, because the judge looked at everything, and he's like, I'm granting this order for protection for 50 years. So we got the 50 years. Then comes this addendum about stating that Wisconsin courts have the ball when it comes to determining custody, because his lawyer is, of course, arguing that it's unconstitutional. Again, the one and only argument they ever have is that it's unconstitutional for my ex-husband, that, it's violating his rights. Again, everything is about him. Everything is about his constitutional rights, not the children, not me, just him. And that a order for protection is not the place to determine custody. I get that, but on the same side, do you realize custody has already been established? Wisconsin has already said no. Wisconsin has already said no contact. In our MSA, your client agreed that I would have sole legal and physical custody with no placement with him until a therapist or the children's therapy team deemed otherwise, and they're all saying no. You were just told no again, and reunification was not recommended. So realistically, this is not affecting your custody hearing at all. But the judge was just like, oh, well, you know, I see Judge Bowles over there. You know, I'm sure he has the guardian ad litem. He's got the therapist. He's got all these records. You know, I'm fully, you know, I realize that he is fully capable of making the proper decision in this case when it comes to these children in custody. He's not, I'm not going to make a decision here and basically make it seem like he's incompetent. I also want both states to be on the same page with this. So he put the addendum in there that Wisconsin would be in charge of this. And then he cited, you know, well, you guys have this evidentiary hearing in February, you know, both sides can call your expert witnesses, da, 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 da. And I'm sitting there thinking, like, what expert witnesses? Like, what does he have? He doesn't have any expert witnesses unless he's going to pay somebody off, and whatnot. And it's already been explained to him that this is frivolous and that there is no reasonable expectation of him that anything is going to change on this when it comes to this hearing, because we have a guardian ad litem who the judges take their word as gold that this man is not to be around these children. We have therapists, one of which is a licensed social worker, saying no reunification at all, and cites why, from a psychological standpoint, reunification should not happen. I actually have those letters for all three of my children, and whatnot. And he's just, and then his attorney's like, oh, well, you know, at this hearing, you know, there's going to be more information that comes to light. There's going to be more information given to this judge so he can change his mind. Like, talking a big game, talking to this judge in Minnesota, like, oh, he made a mistake. Trust me, it's okay. Like, we're going to get this corrected in February. No mention of the notice of intent to file safe harbor in Wisconsin or any of the other crap that actually has gone on in this case in Wisconsin, but just making it sound like, oh, no, don't worry. We're taking her to court in February and we're going to fix this. So whatever, the addendum gets put in there, and basically that means, yeah, he can take me to court in Wisconsin whenever he feels like it until a Wisconsin judge decides to step in and step up and tell him no more. So we leave, you know, the kids are disappointed that they did not get to talk to this judge. They're mad. They don't understand why. We just explained to them that, you know, my ex made this decision, and because of him deciding to agree to it, that just meant that, you know, there's rules in place that mean we don't get to talk. And like my son said, oh, we don't get a voice. You're right, we don't get a voice. So that is the moral of this video, is that the way the laws are written, the way that court hearings are set up to go down, not only, you know, are we already aware that these scales are tipped against victims, that the precautions and everything are set for the abusers, but there is statutes and laws written to where we can be completely silenced. We don't get the choice to talk in court. We don't get the choice to tell a judge our story so long as our abusers make these decisions. They get to make these decisions, like they can contest things and then make decisions, but we as the victims, we as the petitioners are not allowed to contest it ourselves. So me and my children were silenced in Brown County, Minnesota yesterday. Yes, we have a 50-year order for protection, but we did not get to have a voice. We did not get to stand up and say what our story was. We did not get to confront our monster. We did not get to tell a court of law what he has done, what he has continued to do, and the behavior he's done to essentially violate the order for protections that have been in place already and get away with it. My children did not get to use their newfound empowerment to sit there and confront the man that has destroyed their childhood, that has destroyed their lives, that has physically and sexually and emotionally abused them and terrorized them. A court of law basically told me and my children to sit down and shut up, which is exactly what our abusers do. This is exactly what they rely on to continue to be an abuser. The courts are enabling this behavior, and they're displaying the exact same behavior themselves. So I'm sorry, if you are working for the people, if you are representing the people, then you need to let the people have a voice. When I drive 3 hours with 4 children in my vehicle to a town where they are absolutely freaking terrified of the person who lives there, you don't tell us to sit down and shut up, and you don't tell us that we don't get to talk. That should not be okay. That is a statute that needs to be changed. We should be afforded that much at least. And that should go for every state, not just Minnesota. I don't even know how it's written in Wisconsin, because I know the entire system over here when it comes to applying for an OFP is completely different than Minnesota. To apply for OFPs in Wisconsin, I would have to apply for 5 separate ones. Then there would be a guardian ad litem. Then there would be fees for a guardian ad litem. Then there would be the court hearing. Then there would be the lawyer fees. The system is stacked against victims to the point to where we can't afford to protect ourselves. And then they turn around and piss and moan when we haven't done it, or we haven't done it good enough. And then we get to the point where we're dragged through contested hearings. We're willing to not be silent anymore. We're willing to face our terror. We are willing to say no more. We are willing to testify about horrific, embarrassing moments of our lives, things that we don't like to say out loud, things that we don't want to necessarily advertise to the entire world, because we have had to keep this a secret for so long because of shame and embarrassment and fear for our safety. And we arrive and we're ready to do it, and with the flip of a switch, because he's changed his mind, sit down and shut up. Is that really the message you want to be sending to people? That not only do abusers say sit down and shut up, so do the courts.